So it's possible he's talking with that person. But the first agenda, or the first policy on the agenda is the use of fitness center. And John has some changes he wants to go through.
So when we first, I guess a little history, when we first opened the fitness center in 2018 to the public after it was completed, we allowed middle school and high school students to come during community time. That was fine. It was an extra opportunity for them along with the community. We had some struggles with 6th and 7th graders, just maturity level or knowledge of the equipment, and some concerns about, hey, someone's gonna get hurt here, these kids are dropping stuff and putting too much weight on and that kind of thing, or misusing the equipment. So we made it 8th grade and above. 8th graders seem to be fine. They have an opportunity to do the summer school, strength, speed, and agility, where they get an understanding in the room. Last year, I did a trial with a couple parents and their kids that were 6th and 7th graders. I said, let's try this again with parent supervision, knowing that the parent needs to not just go in there, do their workout and leave their kid to run around, but stay with them. And it seemed to work pretty well. So that's what brought this about, to go, all right, maybe we can do this, that if a 6th and 7th grader with parental or guardian supervision would be able to utilize the fitness center. And then there was some adjustments. There were some old hours still on there that I changed to the current Monday through Friday hours. That's the gist of it. So I don't know, any questions on that or concerns?
Well, I was reading through it, and someplace it talked about staff and that they did some sort of orientation or what's that?
So just like someone that would sign up to get a membership, we ask that staff go through that same sign up, and this is a $0 fee. But there's a video in there that kind of explains the equipment. So if they were unfamiliar with equipment, things like that, and the rules and wiping down equipment if you're leaving a bunch of sweat on, something you sat on or your back or something like that. So yeah, it's just a brief online orientation.
And we have someone on the off hours. We have someone in there, right?
Yeah, there's an attendant there for the off hours, and everyone's required to sign in or check in. If you have a membership, they would check in, I would come in, I would give you my name. The person would look up on the computer, say, yep, you're checked in. Kids sign in with their name, grade and date and time that they're there on a sheet.
Has the police department and the fire department expressed interest?
They have taken advantage of it, yeah,
Okay,
especially the fire department, and I would say 30% maybe of the police department. The second shift, third shift people have taken advantage of the off hours, and I really feel that and staff use being open is a benefit to the security of the building in the area as well, because it's just eyes that are there on times when nobody else is there. And I really believe, I don't have any data on this, that because our buildings are so widely used, as well as the things with the fitness center and the open use, we don't have issues with damage, break-ins, things like that, because I think there's people around there all the time, and I'm not taking a chance.
Yeah.
I really do. I really think that contributes to it.
That's a good point. Is there any, just the way that it's written and everything, is there any insurance issues, or that kid is then held under, are there any liability issues with the kid working out with the parent? That would be my only
The
question.
kids that go in there or with the parent are still under our school insurance, just as if they're a student, right?
Okay.
So just as if it was during the school day.
Okay,
It's I guess you could call it extension of the school day, kind of like a school bus.
sure. Yeah, I would hate to see a kid, a dad saying to a 6th grader, like, oh yeah, I know what I'm doing, this is how you bench, and then the kid tearing his rotator cuff or something, we're
Yeah.
responsible for it.
Absolutely.
Um,
And we still ask that the dad or the mom or the grandma or whoever it is that's coming in with them to work out with them, they need to still have a membership and go through the waiver process and the training.
Love it.
eighth graders don't need to have a parent with them.
They do not. No. Like I said, they seem a little bit more mature and
Yeah.
responsible.
The only other thing is 660 is a, where's, at bottom of the second page. Excuse me, bottom of the first page. Yeah, it says 430 to 660. So that's 710.
6:30. Yeah, for the summer hour one, yeah, yep. 660 is military time.
Yeah.
Carry the 4.
Yeah, there's a code to decode. Thank you. Yeah, so summer, school year hours and summer hours are a little different. We found that during the summer, we weren't getting a lot of people on Fridays. People's gonna be doing other things, and if they did, they came right away, got it done, and then left.
Do we want to list the times in there? In the policies, or need to list the times, because then if we ever want to modify, we're not following policy.
Good point.
If we just left it,
Oh.
fitness center will be open to community members and participating businesses. See the district website for available times.
I like that. I mean, it would help with making adjustments to fit the needs of the community without having to go back to a policy meeting.
Good call.
Unless as a board, you feel strongly that these times need to be adhered to. And
Not 660.
Yes. If you don't make one mistake in here, I'm not sure you read.
Yeah.
I've been really bad at ChatGPT because it's been making a lot of mistakes.
Can this go to the board right away, or does it have to wait?
Well, not tonight, it's gonna be, but the next board meeting.
No open-toed shoes are allowed while using the equipment.
Or was that one?
Number 3, community business use. You could be standing there not using equipment and have weights dropped on your toes.
I would assume that's
No, but
all
those
talking
shoes are allowed
about
to
flip flops, right?
Probably that's well in the fitness center.
Yeah, can we broaden that to just not allowed in the room? To be honest, I mean, is that appropriate or not?
We do ask, yeah, people to use the cubbies outside and change before they come in, if they need to change. Or switch.
No open-toed shoes are allowed in the gym. Instead of while you're doing it.
But just in the fitness.
In the fitness center.
Sorry,
Yeah.
Well, that's covered right here. I mean, athletic shoes.
Well, just say no open toe shoes, period,
Are allowed.
are allowed, yeah.
Yeah.
okay.
John, do we have a lot of members? Do we make money on this?
We about break even.
Yeah.
Yeah, it's about a break even.
Still get that.
More of a service, you know, to the community.
Yeah, for sure.
Yeah, when we say break even, that's just covering the supervision costs.
Right.
Not
Yeah.
like the equipment maintenance or.
Sure.
ongoing.
Yes. The one that has become really popular, kind of similar but off topic, is the morning laps one. When I first started, it was 2 or 3 people showing up and you're like, ooh. And it's 8 to 10. Yeah, every one of the 3 days a week. Yeah, so for whatever reason, swimmers are out.
8 to 10.
It's the new lights.
8 to 10 people in the morning, we
Yeah, see
open
where
it
they're
up.
going.
Oh, the water's not 20 years old anymore.
8 to 10 people between 5 AM and 7 AM in the morning.
Wow.
Yeah. So that's.
All right.
Anything else we need to cover on this?
Days on it.
Which is all right, I don't mind.
Thanks for taking the time.
Yeah.
Really dig into that. Well,
Do you need me anymore?
Thanks, Joe.
Yeah, thank you.
Are you sure you don't want us?
Well, when I
Stick
see
to the
Neola, it reminds me of my captain days at the police department. We switched over to Neola and, yeah, I'm glad I'm not doing that.
Hey, if you wanna bring some more stuff for us to look at in this
I
meeting,
think it took 5 years. How long it's gonna take us?
One down from,
Oh, whoops. 16 minutes.
yeah.
Okay. Group health plans. I would recommend. This is the language we have to have. I would recommend. Just not even including this, I don't know. Why it would be needed. I guess we could, it's.
Just reiterating that we have the appropriate plan documents, I think that's a given, we can get rid of it.
You guys want it or not?
I mean, we by law have to provide all coverage, so it's kind of sitting on this.
But we do have a cash in lieu of insurance if we want to spell that out in policy, but again, it's not something you have to have in policy. It's in our handbook. And I think not like putting in. So if we decide to change that, then we have to go back and change everywhere it's written. So I would recommend just not even, I don't know if it needed in policy.
Is it a percentage or is it a dollar amount?
It's a dollar amount.
I think
We do, but we can include it if we want, but it's in our handbook, which is also considered board policy, and that handbook's reviewed every year.
Right.
Yeah. So do you have any problem with not including it, Adam? It's, for year-round employees, it's $300 a month, right?
$3,600 a year.
It's what the cash in lieu of insurance is.
that's a fair chunk of change too. I think ours is only like 120.
120 a month. It's interesting, it's always there's a interesting breakpoint, like when I was in Wheatland, for many years, it was attached to the cost of the single health plan. So as the single health
Yeah.
plan went up, the cash in lieu of insurance went up. So when I went to Wheatland, the family policy was right at $30,000 a year, and the single plan was at 14,000, but they had capped the cash in lieu at like 12,600. So their cash in lieu of insurance was really high. But flip side is they have less than 50%, less than half the employees took the health insurance. So there's that math that, okay, at what point is the cash in lieu
Right.
enough to, okay, the employees look at it, all right, I'll go take the cash in lieu, not take the district plan, and then you're saving the family plan costs. So I don't know, we've tried to put our finger on that, should our plan, like my wife's at Williams Bay is 5,000 a year, so we've looked at it, what's the pros, cons? you run the risk if you increase it, you have to, pay everybody that increased dollar amount. And unless you get more people to shift from the insurance, you don't have a savings on it.
And Franklin, we found going the other way is not what districts are doing. So Mr. Cromie wanted to go to not paying anything. But that was, we found that the area schools are doing as well.
Did they go that way?
No.
No, they
Because
didn't.
it wasn't even an option, but it would put us, Franklin outside the outlier,
Oh, sure,
like.
out of the
you-
competitive market.
Right. No,
Yeah, well, and people factor that in, especially if they don't need the insurance when they're looking at their comp for taking a job or not. But do we need this last paragraph or? Minimum, I don't even,
So. Has the board elected to provide, not to provide minimum value coverage? Yes. Does Neola require us to put it in if that's the case? And the board is aware that failure to offer minimum value health coverage to employees may result. So it is an accurate statement.
so you want that in or not, or? So basically what happens is we pay, because then they go to the exchange, they get the insurance for the exchange, then we pay it's called a penalty, but basically we pay money back in to subsidize the exchange insurance that they took. Is that how it works?
And the penalty is more affordable than. Is that correct? Right,
Coverage.
the coverage.
Well, if you take it out, this policy is very short.
Does that second to last paragraph stay in, Taylor?
This right here, that's part of it, yes. Oh, I see what you're saying. Is this paragraph related to that?
Mhm.
Oh, yeah, this is all related, isn't it? Yeah. This is related to cash and lieu.
That one is also applicable, the second to last one. Or you're saying that one's related to the second option of the
Yes.
cash and lieu,
Right,
okay,
see, and
which would then be covered in the handbook.
we then create a lot of wealth for the employees by erroneously making the cash and lieu go into a TSA. It's supposed to go as compensation, and then the employee gets to choose whether to put it in the TSA if they want. But they just put it in the TSA for 12 years.
That's not income.
Yeah. Then, but because it had grown so much, I mean, I had employees that for sure that had $250,000 in their 403B from that cash and lieu payment company that growth. Not a single one wanted it as compensation after they had done that for that many years
Believe it.
and saw the value of putting it aside like that. All right. Do we want this one in or not? Kyle, Adam,
Dog this fight.
Taylor, do you want it in or not?
Might as well leave it in.
Okay. Anything else on this one?
Not for me.
Woo, we're done with thousands, is that right, Joe?
Oh, no. You just wait till you get to the last 17 pages long.
1619.01.
1619.01.
Scroll back to the top where you were. You had it right there.
So my air conditioner was low on coolant.
It's gonna be the bottom one.
1619.01.
Yep, there you go.
It says $200 a pound is what the coolant costs.
Oh.
And it holds 8 pounds.
You had a leak?
Yeah, apparently has a leak, that's like a 20-year-old PC unit, so I'm like, well, can you just put it in, and he's like, yeah, but it could just leak right out. We're fine, I'll get a new one.
Say like that.
All right, privacy, self-funded health.
So of all the options listed there, A will stay in, that's self-funded. Our medical plan is technically a combo with our our prescription drug plan, so I don't know if we wanna say medical plan with prescription drug plan or leave prescription drug plan as a line item B. Our dental plan is self-funded. Vision plan is not, so we can remove vision plan. We can remove employee assistance plan. We do not have a long-term care plan. And then the health FSA and the limited purpose FSA will stay.
What's employee assistant plan?
We have an employee assistance plan, 24/7 confidential helpline, it's just not self-funded.
So that's like, someone's having a substance abuse issue, or,
We'll just need someone to talk to, just kind of immediately, and can't get into a therapist right away or a licensed counselor.
and you can refer people to the employee assistance plan as well. So, yeah, so we do have that, but why wouldn't we want to include, because it's not part of the self-funded?
Correct, it's not self-funded, this is only
Alright.
listing on self-funded.
All right. And we do have the FSA still with the HSA,
We do,
it's just limited.
and we have both, we have
Okay.
only like 5 of our eligible employees take advantage of it, but it's a way for them to get tax savings to save for their medical expenses.
What's your recommendation for the privacy official?
So right now, we have the HR director listed in all of our plan documents as the privacy official. So to be consistent in our policies here, we probably should hear that.
Below that,
Can I check with my husband to maybe call back? Oh, perfect, I will call you back.
We have it listed as both HR director and both, it is in both roles.
Do we need any of the optional? Or that optional?
that last line is words out on everything.
Yeah. You guys want this language in? I think these last two we should leave in. We want this optional one in or out?
I defer to you.
Our, the gentleman that we work with, he, less is more, and the more language you put into policies, the
Right.
more potential
Right.
entanglements or liability you create, so I think that's pretty much Tim's guidance, is unless you really like, yep, that really fits us, don't include them. Okay. What's next one, Jody?
1619.02.
So this would be the same as the other, right?
This will be the same as the other, but flipped, because these are now gonna list out our fully insured.
Oh, okay,
So remove A, remove B, remove C. Then you're gonna remove long-term care, and then both FSAs. So only things that'll stay is vision plan and employee assistance plan.
Same here.
Let's see. Is it here or Carl?
Oh, wait, leave me.
Did you get her name on this?
Mhm.
And that's all not optional. Okay.
1619.03.
Does that take much of your time?
Not as much as you would think.
Okay,
We're sure that all the safeguards are in place, but it's a normal and expected part.
Well, I haven't heard much talk about the repeal and replace the ACA for some time. Nothing's optional on this one. Anything you guys want to add outside of?
like you said, less is good.
All right, what's the next one, Johnny?
1630.01. Believe it or not, there's one that's double the length of this.
Is this the really long?
No, that's not covered.
We're looking for amounts of leave available. That's be the first section we can make edits in. Right there.
I always, when I see something that says calendar year, I always would like a definition of what
Yes,
calendar year, end of calendar means
yes.
to a school district.
Well, in this situation, because we're talking about federal FMLA here, we use the rolling 12-month period measured forward from the date of an employee's first FMLA usage. So it's gonna be that last option there. That is the FMLA, yep, that is the one that we
And
follow,
those we would strike.
correct. So we, right now, do not require that spouses take a combined total of 12 weeks of leave for a birth or placement of their child. That is not required. So my understanding is that we can strike that.
Did we say that said required?
It says that you can select this upon the advice of legal.
Well, it says may take. May take a combined total of 12.
We would never enforce it. And I don't think an employee would ever say, oh, only limit me to 2.
Only what?
I don't think we would ever want to enforce this because we currently
Oh.
don't enforce it right now.
Okay. I see.
We
what you're
can under
saying.
the law, but where we don't,
So what you're saying is, yeah, we don't limit
no.
because they happen to live within our both workforce. We don't say, well, you only get 6 and you guys get
Correct.
combined 12. Okay. So in a way, that's penalizing the spouses. It's really the FMLA if they both. work the same.
Isabella and Cohen, James.
Oh, so let's see.
This is all non-optional.
James.
The next optional one is gonna be under the heading required staff member notice.
Yes.
Got it, okay. That's our, okay, perfect.
So my recommendation would be to take this out. We have a handbook policy that does speak to this, and it does ask staff to provide as much notice as possible. But in many instances, it's calling me to say, I broke my leg yesterday, I need leave, and so then we're working through that verbally, and they don't require that, I don't require actually someone to like write it in. So to allow the employee the most flexibility to notify is, in my opinion, better.
It seems to me like FMLA is really, it's like that minimum guarantee for employers who are really, hey, guys, you have to give at least this, and I think most of our leave procedures allow for.
I also have a problem when they say timely. What's that?
The next one's all the way down, coordinating leave,
Yes.
substitution.
So we do follow the, under federal FMLA, we do follow that employees must use their available vacation or personal leave for any
if
family
available.
medical leave.
So we don't allow them to just take unpaid leave and say they're on leave.
Yeah. And right now our state doesn't allow for any other paid leaves.
Which I don't know why our employees would want to do that anyway. I think some districts where they pay out at retirement or something, maybe someone won't say that. Kyle, Adam, you guys good with those? A lot of it's not optional.
I'm deferring right over here.
All right. Next one,
1662.
1662.
Yeah, this is fun.
Do we want that included? So we could refer to the EAP
You can
or,
always refer to the EAP.
or do we just, it's
Less
not
is more.
required?
My advice would be to take it out, and then we always know that we can refer to the EAP. Or refer our staff to the EAP.
I think I know what EAP is, but what is that acronym?
Employee Assistance Program.
Okay.
This is a very good definition for employee. We get
Write down your family access account. So easiest thing to do is just go to our website, which is up here. Oh, you. Okay, do you need help?
that term gets thrown around quite a bit. So,
Yeah.
all right, all this is required, sexual harassment. Okay, this is optional here.
Yep. Yeah, so that should take you to the.
Yeah, we should just, yeah, go ahead and have that in there because it refers to right policies. This is,
It's here,
I
so.
really don't want to even touch anything in here. This
Update
is-
that when you log in for the first
I
time.
hate it when people at work give me unwanted gifts. I have to do like a staff presentation. I'm just flashing back to like my favorite Office episodes.
Is that the one with the,
All right. Oh, it's not a laughing matter, very serious. All right.
Do we use the term boundary invasions when we're talking about boundaries with our staff? I've never heard of that.
I have never used that language. We did, all of our staff did training several years ago, which was, whoops, ouch. Which was more on microaggressions, the stereotypes, some of the communication, but no, I mean that, knock on wood, I think, I don't know, have you had to deal with a whole lot of along these lines?
No.
We do have our training suite, but if we did ever have violators as well, we have that whole suite of trainings that we could require, or, the principals could require them to have to complete and so forth. What's the name of our, I forget our software, Vector.
So as through my HR lens, my only concern with this boundary invasions, if we include this, and the bottom it says that must be reported promptly to one of the district's compliance officers. As an outsider looking in, are you really able to identify if this is crossing a line of inappropriate versus appropriate, it's going to fall under one of our existing harassment policies as it is? Do we need to spell it out and make another category and be very, very explicit in this gray area, or can we look at this?
I actually like having this in here, because when we're working with, like from the administrative end, if we have a teacher who crossed that line,
We can pull back,
they can go to as outlined in policy such and such.
alright?
You were telling inappropriate sexual jokes to students. We had a softball coach years ago that was playing inappropriate, would have been easy to, no, this is violation of the policy. I think it helps.
Alright,
I know that's administratively would help them in those conversations if they have a concern.
I'm gonna leave this up on this desk.
Kyle, I don't worry.
Brad.
Thoughts on that?
Or picking up some posts, or dropping off some posts or anything.
Was it inappropriate for me to hug Jeff Brown?
Is it inappropriate for you to? No, may include, but are not limited to, so it's not saying that it is a boundary violation. Like, when I was as a K-12 principal, I wasn't used to students running up and hugging me all the time as an elementary principal, and they do, obviously, that's not a boundary invasion. But, if I was a high school principal going around hugging kids and they're, not wanting to be hugged, or, that's just, it's nuanced.
I don't know what to say, but I know of high school teachers that if there's any sign of distress in the student, they will automatically go up and hug them.
That's not a boundary invasion, right?
That wouldn't be inappropriate.
The question is, if it was unsolicited,
Oh, I see. Oh,
if I see that you're in distress, and I go,
yeah.
what you need is a good hug right now, and I go and give you a hug, and not ask you if you want a hug.
Yeah.
And every time I've heard of it, it's completely innocent.
Right.
But
to your point, does having this policy then allow for us to work with that staff member just to remind and reinforce the importance of boundary invasions? So if that student felt that was unwelcomed, right, kind of educating that team member that may not have been appropriate in that situation.
And the teacher has to know their students too, because there are students that at no time do you ever touch them, they don't wanna be touched.
Right, I've had some where, you put your hand on their shoulder to prompt them because they're not doing their work, and yeah, I have a student, try, don't touch me, I don't like to be touched, and it's different from different students and so forth, that especially, and not that that's the case for all of them, but if they've had a case or issue, abuse or anything like that, then, yeah. So that's why I think inappropriate boundary invasions may include, but are not limited to.
Yeah.
And that's why I do like, I mean, so for some, any physical contact. I had a parent who complained several years ago that, he wanted the football coaches written up because they, smacked kids on the backside when they ran onto the field. And, I had the conversation with the coaches, which is you see it all the time, coaches. They weren't like, it was like, come on, let's go, good job, whatever. I just had to let the coaches just be aware that if you are gonna smack somebody on the butt as they're running onto the field and that person's like, hey, that's not cool, or there's a complaint, I, can't get your back on that, just be cognizant and aware of that. Because that can turn from, that's just what coaches do and so forth to, no, you're as you're told, that's an area that you don't, go. Even though there's nothing sexual with it whatsoever, there's really no intent on that. So that's why I think it's a very nuanced piece, but we had an employee that was a substitute teacher that we felt there were, signs of that going on, and that person was dismissed from being, hugging or not considering that students didn't complain, but there were several teachers that reported, hey, we've got concerns on this. We looked into it and dismissed that person.
I'm fine with this. I'm fine with this. It'd be possible for us to write a policy that would tighten it up to the point where there wouldn't be any doubt.
Yeah, but it kind of clarifies some of those.
Actually, T, I look at T. And when I'm mentoring, I tell them, you should never have the doors closed. And have someone come in during like after school, male or female, doesn't matter.
Anything else to change on this one? Or?
Why is age harassment over the age of 40?
I was
Being it, I've been harassed here.
It's a pretty young threshold.
I know.
Yeah.
That's just interesting.
When we were under 40, we felt like 40 was really old.
Right.
See, I got Taylor said, they're like,
No, no.
That's freaking old. That's a whole decade away.
Oh, to be young again.
Hey,
Yeah, but legally, they can file an age discrimination claim after 40.
Okay, good to know.
Now, we don't have our compliance officer right now. This recommends having a male and female. I think we just have,
Did we add in from last policy meeting, myself as the female and Ryan McBurney as the male?
We did, that was in relation to a different policy, but it
Yes.
makes sense to carry it through
And
here.
it recommends carrying it through consistently.
Yep.
So that'd be my recommendation to the group.
I'll add in that after the fact here.
do we have to put the names or if we can leave it?
You have to put the names.
Okay. Sorry.
Lion McBurney, just out of curiosity. Right move, but
Pupil services.
Being the male of the director leadership team and then having Jason as like the number two if the employee wasn't satisfied with myself or Ryan. And then also Ryan has one of the largest employee bases too.
Okay.
District wide.
So it's more, no, it's more because Ryan happens to be the director of pupil services. Yeah. Now that Emily's not there yet, and they have to have someone to appeal to.
Which would be you.
Oh, good heavens, that's only page 9 of 20.
Yeah,
It'll take the whole time. You should start to fly through this.
I think this, are we okay with it just on the district website? I love Yola. First, yeah, this is, that's fine.
yeah. They didn't want to do it this year.
Mhm.
Jody, what page are you on?
I am probably on a different page than what Jason is. I
Um,
was updating names.
I would
She's on
recommend
page
option 2. We don't have a
Jason's on.
list of separate, there are people out there that will do that for a living if you want a separate investigator to pay, but we've handled these internally and haven't had a problem. If you guys are okay with that?
Of course, there may be situations where you would deem an
Yes.
outside that would be appropriate.
So it'd be this, unless you're asking, just-
The word or in there, so I'm gonna unstrike that.
Wow, and so with it saying 2 days, that doesn't say business days.
So in further, in the beginning of the policy, it defines day,
Okay,
and it says the term day or days as used in this policy means business day.
all right. Do we have the report forms of each building? Or, I mean, it's, we don't have to do the building online.
Yes.
Which ones? Show me.
We copy this so we can actually put in the links.
An interesting question. So if there, let's say we receive a written complaint related to harassment, we have a separate policy that's related to when you receive complaints, that you must present that to the employee that the complaint is about. I don't recall the exact language, but it's pretty much immediate. It's, I think, as soon as, I don't know if it says as soon as practical, but I think it's shall be provided to them. Is that in conflict of if you need to do an investigation on? And say I receive an email that Mr. So-and-so, you know, was harassing me, called me these names, da, 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 da. So one, that would trigger our harassment policy, but two, we also have a separate policy that would trigger our complaint policy where we'd have to notify the alleged perpetrator. Either way, we'd be doing an investigation,
I know.
but there's not a, you know, that person is entitled to know what the, you know, what that complaint was and be able to respond to it.
I think the difference here is, I think our complaint encourages the person that's on the recipient end to address it sooner rather than later, than that this process, I believe, does require you to circle back with the complainant, but it's late for the harasser, and we later in the process. So do we need to just revise our complaint process to be one that's such?
We haven't gotten to that policy, and so when we
Okay.
get there, we can look at that
Okay.
and consider it then. But maybe in the cases of harassment where it would trigger an investigation, that may be delayed and that person receiving it, allowing for investigation.
Yeah.
Okay.
Well, John left it, she's coming to
This is required, here's an option.
someone and then it's. Oh, okay.
I prefer option two. My recommendation would be option two. Don't put a specific timeline on it. I mean, but reports are automatically drop everything, conduct an investigation, we work through as diligently and as detailed as possible.
I can't think of an instance where we would have taken 15 days,
No.
but. And so you guys are aware in the cases of when we do have a complaint and there's an investigation, we will. There's probably been 3 times since I've been here where we suspended the employee with paying up pending the investigation. Just, you need to be at home, not at work while we conduct the investigation. So that's a very common practice. So we're not, you know, driving that out. We did have one investigation that was an options employee that I think it took quite a while to navigate through.
Is that with pay?
Generally, yes.
You know?
'Cause it's
And then if you, depending on the outcome of the investigation, you can
until you
always,
charge or.
yeah, because they gotta get their due process until the outcome of the investigation. As you see it in the news media, people will typically complain like, in this most recent with like the Facebook posts and stuff, when schools, yeah, this person's suspended, you know, with pay, they're like, well, why are you suspending with pay? Because legally you have to do a due process, do the investigation, then when they're, if they're found at fault or wrong, then you can implement the consequence, and you can suspend without pay or change that. Any thoughts on that? Are we okay with that wording? Yeah?
Help me understand a time where the compliance officer, which is right now Director of Special Education or Director of HR, would need to consult with an attorney before coming and reporting to you. I don't think that would ever be applicable. Unless the report involved you, but then that's going to be above and beyond.
It's just saying may consult with, and that does happen often. You guys just let me know. Typically, the way we have it set, because we don't want employees just racking up the legal bills without. So they let me know, hey, is it okay if I contact legal for this or for that?
I guess is this more of the board's stance in this, allowing the investigative team to reach out to the attorney? I'm just trying to figure out what's driving this optional.
I would say go ahead and just leave that in there. I mean, I won't always be here, I bet it's the board, and what's your sentiment on that? Or do you want the investigators to have to go through the district administrator before contacting legal?
You're saying that they would leap over the district administrator?
So currently, like before Taylor, before, the two positions that contact legal quite often is Taylor and special education. And so they always give me a heads up, hey, is it okay to contact legal? We have this situation scenario. This language would just basically give them the okay by policy, but they don't, but it doesn't co-opt the district administrator from saying that, hey.
I would want you to be in the loop.
I think we just strike that. Yeah, if there's something that we need to contact legal for, yeah, I should have a heads up, because then I notify the board, and give you guys a heads up. Yeah. We don't wanna be blindsided on anything, even if we can't do anything, I'd rather you guys know more so if you're trickling or information from the community. Yeah, I would go ahead and include this.
Do you have criteria when it says district administrator must identify the corrective action? I mean,
There's not like a mandated sentencing on this type thing. That's what you meant by criteria.
that's what I meant.
We've always looked at just on a case by case basis, and the part two would be asking the complainant and taking that into consideration. What is, what are you seeking? So that we can return to normalcy if possible, but it could be up to, depending on the severity and what it is. And the persistence, obviously, could be termination and or even referral to law enforcement for charges. And when it crosses a line, we do, I, with the team as well, I tell them, when in doubt, report it. I don't ever want us to be in a position where someone's accusing us of trying to cover up something or not referring to law enforcement. I would rather refer to law enforcement, let them review it, determine whether it's a chargeable
It's
offense or
tricky,
something to
because what
do.
was the local school district that just allowed the law enforcement to make the employment or make the charge?
Uh-huh.
The school district relied on the law enforcement's decision to make their employment decision. So legal is now advising that you make your own decision as a school district, if that employee should continue or not continue with employment, let law enforcement be a separate. So it gets really, really tricky now, and the lines are completely gray.
Because our long leaves where we put them on administrative leave was waiting for law enforcement to do their investigation.
So, yeah.
I don't like that, because let's say like I decide, we make a decision, okay, there was no malintent, you slapped the kid, you weren't meaning to do harm, it wasn't as a punishment. You had no malintent, but then and so you don't terminate
Don't
employment, then law enforcement comes back and says, no, that's assault and battery. That doesn't.
So in that situation, because it was the opposite of what happened that drove this legal case in terms of employer terminated employee, law enforcement came back and decided, made the ruling that, the judge made a ruling that it
wasn't that.
it wasn't. So then full uprising was, what decisions can you make, can you not make as an employer? In this situation though, then the charge is, I think it's gonna be case by case, and it's gonna just be us being very, very critical and crucial as we investigate. And then working with legal, if it's something that would be in a law type situation, working with legal.
See, and
determine.
I don't know, because the other piece too is we're very careful not to impede the investigation of law enforcement. So if I start pulling in and interviewing witnesses before referring over to law enforcement, that's part of why if we have something that rises to that count, we go hands off, turn it over to law enforcement, and then interview our people after they're done, because I don't want to be accused of by law enforcement or the DA of impeding investigation by getting out ahead of it. So we always work hand in hand with them. How would you like to handle this? Sometimes they want to do a co-interview because we have more legal leeway. We have a different legal standard. We have preponderance of evidence. They have beyond reasonable doubt that they have to be able to prove. So we have a lesser standard. to
Then
hold
what's
people
also the
accountable.
statute that allows employees to disclose to us information that then we
Yes.
don't turn around.
We can, yes, we can give them a right where they can tell us the truth and give a full detail. As it's related to their job, but then the law enforcement hates it if districts do that. I've never used it. I have to look up the legal term. But if we do it, it's then like confidential. We can't share what they disclose to us as the employer. If we give them that right. I can't remember the name of the right. I've never used it because I've always been told at the legal conferences that be careful with that. Only in the worst case scenario where you really feel that person needs to be terminated, but you've got to have them come totally clean on it. Would you ever ask for that? And then that preempts, then they don't have to disclose it too. Yeah.
I think all this just highlights the more that the compliance officers and you can be in having discussions about kind of the whole entire situation, the better. No one should ever have to run solo on this.
Well, that's just like at the expulsion hearing a few years ago, we had a kid who their lawyer didn't understand that, like what they disclosed at expulsion hearing cannot be used against them in a court of law. So even if there's a law enforcement officer here as part of the expulsion hearing, if they admit and come clean and whatever they share, that proceeding can't be used against them. for a while, but. And as it relates to this, we don't need it. Okay, the attorney discussion.
I wonder if some of that had been done before, I mean, decades before. I think of one case. And this was before, and, you know, we're, without cause. I mean, we would buy a teacher out just to get him out of the district. I don't know.
It's, yeah, and I think, I wonder if a lot of that went away now that you don't have your, you know, the collective bargaining and that level of standard where now you can non-renew for any reason after a year. Where before it was it's quite
We
difficult,
bought him out.
yeah. Up to 3 years. 2 years.
Funny thing is, we bought a teacher out, and then that teacher demanded to have a letter of reference.
Or I don't know if do we need to let the board, yes, I would leave those both in there. I'm just thinking I would do that, but we might want that ingrained in there, so whoever's after me, it's already in there. And we just know that, yeah, you let the board president and the attorney know.
So instead of one, are you wanting both?
Yeah. The board president and the attorney shall be advised. This is a monstrous. Suspiciously. Post a notice including this policy from each school and place. I wonder, should we just have like a poster with QR codes on? Here's district legal notices and just the title of the QR code to the PDF or to the link.
But
Yeah,
we
in the
have-
bathroom stalls.
We have our annual notices
board.
document that's part of, at least for our families, part of registration.
Okay.
And they have to acknowledge that they've read it. Now for staff, it would be part of the employee handbooks.
Yeah, this says we have to post, so we post that notice at each school.
And the school district.
It was on our
Notice.
website.
Right,
So-
that's the problem I have with this one though, it says it has to be posted at each school. In a place accessible to the district, community and members of the public. Notice including this policy against harassment.
Does anybody read that stuff and they just go on the website?
Oh, yeah.
And we have our employee bulletin
But
board, we
this
could,
must be a state statute or something. for
we have
the-
our employee bulletin board that we could put it there, but the employee bulletin board would be accessible to the community and members of the public.
It would almost have to be like in the front office, of every.
Or the foyer, yeah,
Here, close.
publicly accessible, yeah.
But to your point, Jason, can we just post a QR code out there? Would that qualify as a link to this policy, so that way if the policy is ever updated, we're not trying to run around district. Would be a huge tedious task, but every time it's updated,
Yeah, because we're not gonna post this book.
no.
Is this a state requirement?
or federal.
Well, I would ask, what else is required for us to post in every building? And then just,
Compile it onto like
Yeah.
one poster or
Yeah.
something.
I mean, I'd be concerned if I came in and saw just a poster saying harassment.
As long as it's got the officers' pictures on either side of it.
We could do it like a cool looking creative poster with the district office picture and like picture of each of the board members holding a little QR code, like, where's the, guess which disclosure?
Yeah.
Kind
My question is gonna be this QR code alone,
of like, where's
is
Walt?
that, if we're doing it for legal reasons, is it gonna be enough for legal, like posting requirements? So that would be a side question.
Or just ignore it, wait till someone.
Okay.
We have our employee bulletin board, we're at least compliant there, it's the members of the public that we're not compliant with right now.
Well, we haven't adopted this.
Yeah.
True.
We'll give it a little bit of time.
No, but at the end of all of this, we probably should make a notation, what are all the public disclosures, do we have to have, which ones do we have to have posted in a public location? And I would think making a poster with a title and maybe a QR code so they can scan and go to the full text.
You know, you could have the district mission statement at the top. And then have the rest of
Public
it.
disclosure.
Yeah,
Mhm.
you know, it doesn't have to all be negative.
Yeah.
And maybe,
We can modify a poster, maybe that is sufficient, just public disclosures with a
Mhm.
QR code in there all. Type of-
That could go wrong. I was like, ooh. Okay.
We could even do it as a sticker on our, like our poster, just down on the bottom. All right, do we need any of the bottom ones?
Because it'll all be encompassed in the above, so it's just a redundancy.
So we are gonna pay a lot of money to write this poster. All right. Anything else on this?
yay.
Is there another one, Jody?
That's no, that's the last one.
Finish the thousands.
And we do have some early
Sorry.
grad requests.
We weren't gonna go
Or
to
we-
finances?
Oh, we could go
Ow.
to finance.
Oh, come on now.
I say we do at least one finance one since Chris said. it.
Make his time worth it.
I say no.
Understanding.
You say
what
no?
Policy itself is.
Yeah, we could, because the first finance one, in meeting with the Neola rep, when Chris and Bill were working together, he did not recommend that we adopt it, so.
Ooh, which one's that?
6108,
Where is this?
Authorization to make electronic fund. But I lost it.
Why did he not wanna?
Oh, here you
my note says it was just more procedure, not necessarily policy.
Sounds good. So that's what. Oh, what was the gentleman's name?
Tim.
Tim and Bill talked mostly, and I listened like 99.9% of the time about, does it need to be written down, or is it something that we already do as good business practice? And that was kind of procedure, right? Right, policy versus procedure, and so that was.
go. How many of these are procedure? versus policy? I don't know.
Yeah.
That was the general meeting, so that was kind of the guidance between the two of them.
That was a nice benefit of having Tim there, because he could tell us, like, most districts don't do this, and here's the
Yeah.
why.
All right. So are you guys okay with just not dealing with 6108?
Yep.
All right. If you're okay, we can go to the early grads.
Let's do it.
You'll wanna, stop the recording.
Oh, yeah.
Yeah,
Ruth make a motion.
Yeah.
I moved to go into closed session.
Second.